Understanding Schedule 3, a lifeline for onshore partner visa applicants. Schedule 3 is a specific part of Australia's Migration Regulations 1994. It provides a special pathway for certain individuals. These individuals are applying for an onshore partner visa, specifically the subclass 820-801. They might find themselves in Australia without a currently valid visa, or they may hold particular types of bridging visas at the time of their application. Schedule 3 is incredibly important for these applicants. It offers them a potential route to remain in Australia while their partner visa is processed, rather than being forced to depart. This provision can be vital for keeping families together and addresses complex visa histories. Schedule 3 is designed to assist individuals who are considered unlawful non-citizens. It also extends to those holding certain bridging visas. The fundamental aim is to support genuine and ongoing relationships. These relationships are typically with Australian citizens, Australian permanent residents, or eligible New Zealand citizens. Schedule 3 offers a mechanism for these individuals to attempt to regularise their visa status. Crucially, they can do this from within Australia, avoiding major disruption. Life can present unexpected challenges, and sometimes these challenges lead to complications with visa status. Schedule 3 acknowledges these human realities. The primary challenge that Schedule 3 directly addresses is the situation of applying for a partner visa while being onshore in Australia, but without holding a substantive visa. Ordinarily, to lodge a valid partner visa application from within Australia, an applicant must hold such a visa. Schedule 3 serves as a critical exception to this standard requirement. However, it is by no means an easy exception to meet. It comes with its own set of additional stringent criteria. Applicants must satisfy all the usual partner visa requirements, and on top of that, they must also meet the demanding specific conditions laid out in Schedule 3 itself. This is where the true complexity of this pathway begins. The rationale behind Schedule 3 is a recognition by the government that individuals can sometimes become unlawful due to circumstances genuinely beyond their effective control. Furthermore, the government understands that the compassionate elements of a legitimate spousal or de facto relationship may warrant special consideration. Therefore, Schedule 3 aims to strike a balance between maintaining immigration integrity and acknowledging the profound human aspect of family life. It must be understood, however, that this provision is strictly intended for exceptional cases. It is not designed to be a general loophole, and the demanding nature of its requirements clearly underscores this important distinction. A thorough understanding of this pathway is absolutely essential for any potential applicant. The term waiver in the context of Schedule 3 is key. It is not a distinct separate application form. Instead, it refers to the process of meeting the specific criteria within Schedule 3. Applicants who do not hold a substantive visa need the department to effectively overlook this standard requirement. This is not granted automatically or lightly. Applicants bear the significant burden of proof. A critical element they must demonstrate is that their unlawful status or their lack of a substantive visa arose due to factors beyond the applicant's control. This particular phrase is interpreted strictly by the Department of Home Affairs. Comprehensive and credible evidence is absolutely vital. So, what constitutes factors beyond the applicant's control? These are typically serious and unavoidable situations. For example, a severe illness or sudden incapacity could physically prevent an individual from lodging a timely visa application. It could also prevent them from departing Australia before their previous visa expired. Another instance might be if an applicant received demonstrably incorrect advice directly from the department itself, or if a previous migration agent made a significant error or was grossly negligent and the applicant could not reasonably have foreseen or rectified this. The applicant must clearly show they were not willfully non-compliant or simply neglectful regarding their visa obligations. Beyond establishing factors outside their control, applicants must also present compelling reasons for granting the visa. This is another essential pillar for a successful Schedule 3 case. Merely being in a genuine and ongoing relationship, while necessary, is often not sufficient on its own. The department needs to be persuaded by reasons that are exceptionally strong, persuasive, and frequently involve compassionate circumstances. These compelling reasons must be substantial enough to outweigh the fact that the applicant has not maintained a lawful visa status. The totality of the applicant's circumstances must present a powerful argument for the visa to be granted while they are on shore. The department will carefully weigh all these factors. Concrete examples can help illustrate what might be considered compelling reasons. The presence of an Australian citizen child who's dependent on the applicant is often a very significant factor. This is particularly true if the applicant is the child's primary caregiver and their departure would cause severe disruption to the child's life. Similarly, if the applicant's Australian partner or spouse suffers from a serious medical condition and heavily relies on the applicant for essential daily care and ongoing support, this can constitute a compelling reason. The core consideration is often the significant hardship that would be caused to the Australian partner, child, or even the applicant if the visa were not granted on shore. Navigating Schedule 3 involves adhering to very strict application timelines. These critical deadlines are detailed in clauses 3001 and 3002 of Schedule 3 in the Migration Regulations. As a general rule, an application invoking Schedule 3 criteria must usually be lodged within 28 days. This 28-day period typically commences from the relevant day, which is often the day after the applicant's last substantive visa ceased to be in effect. Under certain more limited circumstances, there is a possibility to make an application within 12 months of this relevant day. Accurately determining the correct applicable time frame is absolutely paramount. Failure to meet these deadlines means the application may be deemed invalid with no flexibility offered. In addition to the strict timing rules, there are other general conditions outlined in clauses 3003 and 3004 that applicants must satisfy. They are required to demonstrate that they have substantially complied with the conditions attached to their last substantive visa. This requirement for substantial compliance excludes the breach related to the visa simply expiring. Furthermore, they must also have complied with the conditions of any bridging visas they have held subsequently. Applicants also need to satisfy the decision maker that they would have met all other standard criteria for the partner visa if they had been in a position to apply when they last held a substantive visa or lawfully entered. A critical point is that their last substantive visa must not have been subject to a no further stay condition, such as condition 8503, 8534 or 8535, unless that specific condition has been separately waived. Applicants frequently encounter significant hurdles when trying to meet Schedule 3 requirements. Beyond the challenge of convincingly demonstrating compelling reasons, proving substantial compliance with previous visa conditions can also be quite difficult. This is especially true if there were minor, perhaps unintentional, breaches in the past. Gathering a sufficient volume of credible, persuasive evidence for all claims made is often a substantial undertaking. This includes comprehensive evidence of the genuine nature of the relationship. It also includes detailed evidence explaining the circumstances that led to the unlawful status and robust proof of the compelling circumstances. Many individuals, unfortunately, underestimate the depth and corroboration of evidence that the department requires, leading to application refusal. It is also important to be aware of the no previous Schedule 3 grant rule, which is found in Clause 3005 of Schedule 3. This rule generally stipulates that an applicant cannot be granted a visa based on satisfying Schedule 3 criteria if they have, on a previous occasion, been granted any visa or entry permit on the basis of meeting Schedule 3 requirements or similar provisions that existed in past regulations. In essence, this means that recourse to Schedule 3 is typically a one-time concession. This restriction further underscores the critical importance of preparing the strongest possible application from the very outset, as a second opportunity under these specific provisions is usually not available. This is a vital piece of information for all potential applicants. Applications involving Schedule 3 criteria are exceptionally complex undertakings. It is crucial to understand that these are not straightforward or standard visa applications by any measure. The Department of Home Affairs subjects these cases to a highly rigorous assessment process. Each application is meticulously considered on its own individual merits and demerits. The decision-maker will carefully evaluate the compelling reasons presented by the applicant. These reasons are then weighed against the applicant's history of unlawful status or any previous instances of visa non-compliance. The discretionary nature of this assessment means that outcomes can be quite uncertain without an exceptionally well-prepared and robust case. It is undoubtedly a high-stakes process. Given this complexity, seeking professional assistance is not just advisable, it is often critical for success. It is highly recommended that individuals consult with a registered migration agent or an experienced immigration lawyer. Ideally, this professional should have specific expertise in handling complex partner visas, and particularly in navigating the intricacies of Schedule 3 criteria. These experts possess a deep understanding of the relevant legislation. They know what constitutes persuasive evidence in the eyes of the department. They are skilled in how to structure and present a compelling case effectively. The potential consequences of a visa refusal, which could include removal from Australia, are severe. Attempting to manage this intricate process alone is generally not recommended. A substantial amount of detailed and specific evidence is required to support a Schedule 3 application. Applicants must provide comprehensive proof that their relationship with their Australian partner is genuine, continuing, and mutually committed. They will need to prepare detailed written statements. These statements must clearly explain the sequence of events and circumstances that led to them becoming unlawful. They must also furnish corroborating evidence supporting their claims of factors beyond control. Furthermore, very strong proof of the compelling reasons for granting the visa is essential. This evidence might include medical reports, psychological assessments, letters from schools or support services, statutory declarations from family and friends, and detailed financial records. The quality, relevance, and thoroughness of the submitted evidence are paramount. Regarding potential outcomes, if the Schedule 3 requirements are met and the waiver is effectively granted, the substantive partner visa application can then proceed to be processed on its merits. However, it is a reality that a significant number of applications invoking Schedule 3 are refused. If an application is refused, the applicant usually has rights to appeal this decision. The appeal is typically made to the Administrative Appeals Tribunal, AAT. These appeals must be lodged within strict non-extendable time limits. The AAT conducts a merits review, meaning it re-examines all the facts and applies the relevant law afresh to make a new decision. However, the appeal process itself can be lengthy, costly, and add considerable stress, reinforcing the vital importance of submitting the strongest possible application in the first instance.